Ready?
Yes, yes, Your Honor.
Yes. Devin Heflin, come down.
Let me get this stage.
Hello.
Hello.
Right, so we've attempted to have you brought out of court twice, but they tell me you're disruptive. Let me tell you what ends up happening when people are disruptive. They'll bring you over for trial because legally, there are certain parts of a trial that you need to be present for. Did you ever see the movie involving Hannibal Lecter? They will bring you over to trial, strapped down to a chair with a face mask on, and guess what? Your attorney will try to explain to the jury why you're strapped down with a face mask on. The jury will take it to mean whatever they will mean, and you'll be going to trial strapped down. Do you understand? So do not be causing issues when you're being brought over. Do not be trying to flood toilets. I always think when people flood toilets, I always think they should be required to clean it up because then they won't do it anymore. Somebody had to come and clean that up. So where are we?
It was actually our first setting today, Judge. I have downloaded the discovery. There's some videos I need to be looking at. They did give me an offer this morning. My client has declined the offer as of today. I'm going to review the video evidence, have another visit with him. And so at the next setting, we can look at that offer again.
All right, Ms. Ferguson, recall this in 3 weeks for a plea deadline date, please.
I can do the 20th.
All right, we're coming back on February 20th. On February 20th, you need to let the court know whether or not you're accepting the state's offer. If you choose not to accept the offer, that's completely up to you. What will end up happening is your plea deadline date will be expired and you will be going to jury trial. And if after that point you decide to enter a plea, you'll have to plead open to the court because the court will not consider any plea bargain agreements without good cause. Do you understand?
Hold on. I only get one plea.
No, what will end up happening is on February 20th, my understanding the state has made an offer to you. People, sometimes they need time to think about offers. Sometimes people receive an offer and they want to make a counter offer. They want to say, I want to accept this offer, but if you offer me this, I'll accept that. So what I'm telling you is if there's any other negotiations regarding the plea bargain agreement that the state has offered, that needs to be done by the 20th. And on the 20th, you need to let the court know whatever agreement perhaps you all have come up with. On that date, you need to let me know whether or not you have an agreement, whether or not you're accepting the plea. If you say, I'm not accepting the plea, then what's going to end up happening is you're going to be put on the trial docket. And let's say trial is set and you see a jury coming in and you're like, shucks, I need to plea or I want to accept a plea. The state may have an offer available that they're offering to you, or they may say, nope, jury's here, we're going to trial, we're not making you any more offers. Or they may say, we're going to make you an offer. If they do, then I will only accept a plea bargain agreement without good cause. And what do I mean by that? I mean, you file paperwork saying, hey, I want you to consider this plea because now I changed my mind, I want to enter a plea. There needs to be a good reason for me to accept a plea when it could have been done on the 20th. Because once a jury comes up, the jury's been brought out, we're going to trial.
After so basically it is only get one plea in trial.
No, you get a chance to say on the 20th.
Get one plea, then I get to offer a plea, then it's trial.
Yes. So what ends up happening on the 20th?
Why trial come so soon?
Because in this court, when people want a jury trial, they get a jury trial quickly. I don't have people staying at the jail. I don't let people stay at the jail for years, months, because I don't think that's the way it should be done. I think you're entitled to a quick trial, speedy trial, fair trial. The complainant is entitled to a quick trial, speedy trial, fair trial. People are not entitled to sit at the jail for 3 years or 2 years or 9 months waiting for a jury trial. So I'm working my way through all of the cases that were on my docket before I even became a judge. And people who want trials, they're being given trials. We just finished a trial yesterday, and we are starting a trial this afternoon.
Devin, I'll talk to you on Zoom.
All right.
We're getting a reset.
So that's what's happening.
It's just a baby question.
Sorry?
Devin, my advice to you is we'll talk on Zoom, okay?
All right, so you'll come back on the 20th. You
Thank
understand?
Judge. We'll have a visit before then.
All right, thank you. And I'm sure you'll explain
I will.
everything. All right, court is calling 2023 CR 10633, State of Texas versus Devin Heflin. Could I have parties announced for the record for the state? Defense?
Carl Alexander from Meredith Chacon for Mr. Hudson.
And are you Mr. Heflin?
Yes, ma'am.
Any objection to this attorney standing in for Ms. Chacon?
Uh,
All right, so what is happening, Mr. Heflin, is this is an attorney that works in the same firm as your attorney, Ms. Chacon.
Yes, ma'am.
My understanding is that a plea bargain agreement has been worked out between Ms. Chacon and the state. All right, so Ms. Chacon probably had to go to another court. So this attorney is standing in for her. My understanding is that this attorney is not here to change your plea bargain agreement. He's just here as an attorney standing in for Ms. Chacon so that the plea can be completed. If you would like, we could wait for Ms. Chacon to come back, or either you can go forward with this attorney. Which do you prefer?
You said you work with her?
Apart, we're in business together.
So you know on her case, though?
Yes. She knows mine.
All right, do you want to speak with him?
Yes, ma'am.
All right, if you all will step back and talk to each other. Okay,
Sorry.
all right,
I had to take comments.
no problem. And for the record, for defense?
Meredith Chacon for the defense, Your Honor.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
All right, Mr. Heflin, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. I did understand it.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Heflin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 years in the prison and there are no applications. And I see outside the agreement, there's a request for an affirmative finding of family violence. Did you understand if I find that there's an affirmative, if I find that there's family violence and that this is a case of family violence, and I enter an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Did you understand?
Oh, yes, ma'am.
And did you understand you would not be allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
All right. And also, if I find that there is a deadly weapon involved, there will be an affirmative finding of deadly weapon. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
State,
Yes, ma'am.
defense.
Yes.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting no contact with Kaydin, Kaydin Butler and James Butler, affirmative finding of deadly weapon and affirmative finding of family violence. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Stand up for State Exhibit 1 with all attachments.
And Your Honor, we have no objection. I have gone over the attachments with my client.
All right, I'm showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Also, I forgot to ask, are y'all proceeding on both counts?
Yes, Your Honor.
Yes.
And are you pleading no contest to count 1 and count 2?
Yes, ma'am.
Okay. And are these counts to run concurrent?
Yes.
The court, no problem. The court will review states exhibits 1 and attachments for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client was on a parole that had been transferred here to Bear County and would like you to give him credit for that time to run concurrent as well. The state had no objection, is my understanding.
No, Your Honor.
All right, and which, do you have a cause number or anything?
You might.
And the court will find you guilty of count 1, guilty of count 2.
And for the record, Your Honor, the victims are also aware of this, Your Honor, and in agreement with this. And I do have the case number whenever the court is ready.
Okay. Count 1 and count 2 will run concurrent. And then what is the cause number for parole?
19 CR S 238347. It's out of North Carolina.
All right, and the court will give you credit for any time served in that cause number and credit for any time served, of course, in this case. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Caden Butler and James Butler. And I'll sentence you to 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not in the state, Your Honor.
No, Your Honor.
All right, I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea, because I followed your plea, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed, and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
20. I just turned 21 2 days ago.
All right, so I don't know what was going on with you at the household or what's going on with you in your life. If there's a mental health issue or anger issues, that's something that you're going to have to work on. Otherwise, you may find yourself living in a prison. You understand?
Yes,
And when you get to the point in Texas where they stamp you as a habitual, that means in some cases your minimum sentence is 25 years. You understand? All right, do better, okay?
Well.
All right, good luck to you.
Good luck.
appreciate it.
And we keep it working like Oouchie the boss. We tryna catch out like we hit us a fault. We gotta win, ain't taking no loss. 'Cause we in the game.